Good afternoon, everyone. Welcome to the Appellate Division First Department. Oral arguments for today, December 5. So please, attorneys, just ask for the time that you actually need to get out the salient points of your argument. We are familiar with your arguments. We've read the briefs. Some of the briefs were very, very long, and we read those. Some submissions, we received this at like 11:45, 76 pages. We read as well. You know who you are. So again, we are very familiar with these briefs, and we've spent countless hours reading them over. So again, ask for the time that you actually need to get out the salient points of your arguments. People v. Miguel Garcia. Four, 1, and 4. Cornell University versus Pasadena. That matter is submitted. Matter of VH Children, that matter is submitted. McWashington versus AOD International. Yes, respondent? 4, 1, and 4. Zurich American versus HBCU Holdings.
For the appellate, Your Honor, 12 and 2, please. Request 5, Your Honor.
Okay, 10, 2, and 5. People v. Joseph Foster. That matter is submitted. People v. Pedro Gomez.
Request 5 and 1, please.
515. Gibraltar Contracting versus Tully Construction. So I do not have a respondent. Did you wish to submit or did you wish argument time? Salient points. 3 minutes for those salient points. People v. Ernesto Sobernanos. That matter is submitted. Mahia v. St. Barnabas Hospital. 6, 2, and 4. Justice Rodriguez is recused on that matter. Curtin versus the City of New York.
Your Honor, if the appellant's counsel is not here, I'm prepared to submit for respondent.
Matter is submitted. U.S. Bank v. EquiFirst Corporation.
For the appellant's respondents, 10 and 2.
Yes?
For respondents and cross appellants, and
You do not, I'm sorry, you do have a cross appeal now? Sure, 6 and 2, 6 and 2. Bellara versus Lido Inc. That matter is submitted. People v. Andy Aragon. 626, that matter is going to be called first, by the way. Global Merchant v. Tammy Tran. There's no respondent. Did you wish to submit?
No, Your Honor.
Okay, 4 minutes. People v. Clifford Taylor. That matter is submitted. State of New York versus Popel.
appellate request 10 and 3.
I'm sorry, who do you represent? And how much time did you request? 6 and 2, 4 and 3. People v. Alan Moore. That matter is submitted. Quan versus HFZ Capital Group. That matter is submitted. First matter for argument I'm sorry, there's also a Article 78 that's on the calendar as well. First case for argument, as I stated, is Andy Aragon. Yes, you may proceed.
May it please the court. Michelle for Andy Aragon. The prosecution relies on the search incident to arrest exception, and therefore it had the burden of showing that Officer McKnight formed an intent before the search to arrest Mr. Aragon for possessing a tiny amount of marijuana. It failed. The prosecution easily could have asked Officer McKnight at the suppression hearing about his intent.
And that would be based on what cases? What Court of Appeals case are you referring to? Where the officer would have to express either an intent to arrest or an actual arrest?
I will rely on People versus Reed, Your Honor.
And is there a matter in this court which also would have precedent over your arguments?
Sorry, could you repeat the question, Your Honor?
Is there also a First Department case which also controls in this instance?
Oh, yeah, I mean, there's people v. Mangum that certainly applies as well, people v. Simmons, but I think people v. Reed is sufficient to control this case because that makes clear that the prosecution has the burden of showing the intent. And now, the prosecution, like I noted, they easily could have asked Officer McKnight at the suppression hearing about his intent, but it failed, and that failure resulted in a sparse record before you. Officer McKnight never said, yes, I was going to arrest Mr. Aragon for possessing marijuana.
Was he ever asked directly? Was he ever asked a question directly, though?
Certainly not on direct. I will note that on redirect, the prosecution did try to ask him, why did you search Mr. Aragon? But then the court blocked that testimony because that went beyond the matters, went beyond the scope of cross. So I think that question there on redirect is telling because I think what it reveals is that the prosecutor realized that belatedly that he hadn't carried their burden of showing an intent.
Counsel, isn't there enough in the record to infer that his intent was to arrest?
I don't think so, Your Honor. So I think the strongest piece of evidence that respondent relies on is the fact that Officer McKnight asked Mr. Aragon to step out of the vehicle and then frisked him. But that kind of behavior is perfectly consistent with an intent not to arrest. And I think actually empirically, in most cases, it's not accompanied by an intent to arrest. For example, during a routine traffic stop, if officers have reasonable suspicion that the occupants are armed and dangerous, they're allowed to ask the occupants to step out and then frisk them for weapons, even though there is no intent at the time of the search to make an arrest.
But there was no effort on the part of the people to suggest that the frisk was because of that.
Yes, that's correct, Your Honor. I don't think
And weren't the other occupants of the vehicle similarly searched?
That's exactly right, Justice Shulman. The other occupants, there were about 3 or 4, they were all asked to step out one by one and then frisked. And none of them were arrested. And respondent hasn't given any explanation or suggestion that the officers intended to arrest any of them.
And counsel, here we're sort of limited by Supreme Court's holding that this is a search incident to a lawful arrest as opposed to analyzing it under stop and frisk, correct?
I think that's right. You know, to be candid, in our opening brief, we did address an alternative argument if you construed the lower court as relying on the stop and frisk.
Well, the lower court, I think, was clear. He said to make sure that that it was ruling that it was based on stop and search incident to a lawful arrest.
I mean, I think that's a fair characterization, and certainly respondent at this point they've staked their entire suppression argument on search incident to arrest. So I'm happy to limit it to that issue, and I think the legality of the search has to stand or fall with the search incident to arrest exception.
And could the defendant have been arrested? We're talking about marijuana. Was that an arrestable offense, or would it be a summonable offense?
Yeah, so I mean, in theory, it was arrestable. I think there is certainly probable cause to believe that there was unlawful possession of marijuana. But you know, again, that doesn't matter because as people made clear, and I'm quoting from the decision here, it's irrelevant that because probable cause existed, there could have been an arrest without a search. The search must be incident to an actual arrest, not just a probable cause that may have led to an arrest but didn't. And just one other point on that. It was an arrestable offense, but as we noted, NYPD policy at the time directed officers not to make an arrest in these cases. And in fact, Mr. Aragon, he could have been found with up to 20 times the amount of marijuana that was involved here, and NYPD policy still would have said, don't make an arrest, issue a summons.
But it doesn't really matter because it's an arrestable offense as per the penal law.
Oh, so I do think that kind of objective evidence does matter. It's probative of the officer's intent.
But even in the data that you provided, despite that directive from NYPD, arrests were still made.
Still
For
made.
this type of incident.
That's true, but it was in a tiny fraction.
A fraction of what it was, but nonetheless, arrests were made.
Yes, but I will note that when we're talking about percentages, we're talking about like around 1% or even 10% if you look at the higher charge of the fifth-degree possession. Even if it's like 10% of cases result in arrests, that easily defeats the prosecution because they have to show, it's their burden, right? So they have to show at least a greater probability than 50% that an arrest would have happened here. So just on the pure data, they would lose as well.
So you're saying that at the time that he was ordered out of the vehicle or asked to get out of the vehicle, he was not under arrest at that point?
That's correct, Your Honor. And I'll note, the other indications of why he wasn't under arrest. Officer McKnight didn't tell him he was under arrest. He didn't place him in handcuffs. And then during the frisk, when he pulled up this Ziploc bag that has a powdery substance in it, and he asks them what's inside it. I think that's very powerful evidence that Officer McKnight didn't think he was placing Mr. Aragon under arrest. Because if he did think that, then Police 101 says you have to Mirandize someone you're arresting before you ask such an obviously incriminating question. And Officer McKnight, we know that he was a 6-year NYPD veteran. He made hundreds of arrests, and respondent hasn't offered any reason for how he could have committed such an egregious mistake if, in fact, he did have this intent to arrest Mr. Aragon for marijuana possession.
Good afternoon, Jamie Maston for the People.
So you rely on this search incident to arrest basis for this, right?
That's correct.
So what evidence, if any, is there that the officer intended to arrest the defendant before he searched him?
Sure. So I'm pointing the court's attention to the officer's actions, and I want to focus on what's on the record in the suppression hearing, because the defendant in their argument relies on numerous facts which are before the record. They were facts that were only adduced at trial, and as this court knows, it is improper to rely on evidence only adduced at trial in order to determine the propriety of the suppression court's ruling. So things such as the exact weight of the marijuana, what happened to the other occupants of the vehicle.
What testimony was there at the suppression hearing which indicates that Officer McKnight intended to make an arrest before he conducted the search?
Sure. When he smelled marijuana and when he observed marijuana, he immediately directed the defendant to step out of the vehicle. This is significant, and it's
But he could do that based on the proper car stop, right? The law allows him to do that just based on the car stop.
It's possible, yes. However, I think we need to look at the court suppression ruling because
Does
the
he
court.
say that he intended to make an arrest?
There's no explicit statement. However, we
And in
need to.
fact, don't you concede that at the time that he was searched, that he was not under arrest, although the officer had the intention to arrest him?
He was not under formal arrest. There was an intent to arrest because the officer is taking him out of the vehicle so that he can take custody of the individual, and obviously removing
How
him.
do we know this based upon the testimony in the record? How do we know that this was the officer's intent?
That it's the sequence of events. The officer is clearly responding to every increment of increase in indicia of probable cause. So once he reaches the point of developing probable cause to arrest for the marijuana, which there is no dispute, there was probable cause to make that arrest.
Well, then why didn't, I'm sorry, I didn't mean to interrupt. Why didn't they arrest the other occupant for constructive possession?
That's not in the record before the suppression court. There is testimony at trial as to what happened to the other occupants, but those facts are
The
not.
problem is that his actions, you're saying that we have to look at his actions to determine what his conduct was, and I agree that normally that's what we do. But his actions is also consistent with just an officer ordering people out of a car after a lawful car stop, which they're allowed to do. It's also consistent with asking someone to exit a vehicle so you could do a frisk, assuming they have the reasonable suspicion. So how are we to differentiate between those three options?
And what I was going to add was that the defendant is a rear seat passenger.
Right.
He's a backseat passenger. He's not a front seat passenger. He's not the driver. He's a backseat passenger.
He's the backseat passenger, but he's the one who has the marijuana open in plain view on his lap. And I take the point, Justice Rodriguez. I would point to the suppression court's ruling. The court said, quote, there was probable cause for the officer to order the defendant out of the car. He doesn't say in his ruling that he asked the defendant to step out of the vehicle as a routine traffic
That statement from the court, really, what does it mean? Because the officer didn't need probable cause to order him out the car.
I think it's an implicit understanding that the officer developed probable cause and was acting upon it to take custody of the
Well, there's no doubt that there was
individual.
probable cause, right? I don't think anyone contests that. The marijuana was on his lap. The question is, he doesn't have to arrest him, though, right? He could exercise discretion and not arrest him. He could issue him a summons. He could let it go.
It's true, but why else would he secure the individual for an arrest, and why else would he secure the
That's the
contraband?
question.
Why else would he retrieve the marijuana? And it's not just.
You have the burden of proof, do you not? Did you need to elicit that was the officer's thinking at the suppression hearing?
And I have to go back to both Reed and Magnum. Both those cases, especially Reed. How do you distinguish Reed?
Reed had very problematic testimony, and I just want to go back to the holding in Reed. Reed says, quote, for a valid search incident, it requires proof that an arrest occurred or was about to occur, end quote. But it doesn't say what type of proof. It doesn't mandate that that proof must be in the form of an explicit statement by the arresting officer that, yes, at this point, I was going to make the arrest. And I would point this court's attention to the Fourth Department's holding in People v. White. Those cases, the facts in that case
So basically, you want us to conclude that he intended to arrest him because he ordered him out of the car.
in conjunction with the fact that he retrieved the marijuana and coupled with the fact that he did eventually make an arrest for marijuana. And so
But he made the arrest because of the cocaine that was found after the frisk. Let's be clear, marijuana was a separate charge, but the top count was for the cocaine.
it's true that the top count was narcotics. It doesn't erase the fact that he had probable cause for marijuana, that he acted on that
You
intent.
contest your adversary's position that the marijuana, that the highest charge for the marijuana would have been a violation.
I think the arrest came through on the rap sheet that was before the suppression court as 22110, which is a misdemeanor. But either way, it doesn't matter because he had probable cause to make an arrest for possessing marijuana. He acted on that probable cause by securing the individual and securing the contraband. And because he had that subjective intent to arrest at the time that he made the search, this was a valid search incident to lawful arrest. The problematic testimony in both Reed and this court's ruling in Magnum was that each officer in those cases expressly disavowed the people's theory that it was a search incident to arrest. Because after all, you cannot have a search incident to arrest if the officer avers that he had no intent to make an arrest in the first place.
No, it was that they did not articulate that they were going to make an arrest. They did not articulate, in neither case did they articulate that it was their intent to place the defendant under arrest.
A little different, I would read it. In Magnum, the officer testified, quote, "It was only after they discovered the gun that the decision to arrest was made." Contrast that with this case, the Fourth Department's
But Reed was a DWI, right? Reed was.
Yes, Reed
It
was
was
DWI.
clear that the officers had the right to arrest that defendant for DWI. But by the same token, the officer never testified that he or she intended to arrest the defendant for the DWI.
The officer testified he had no intent to arrest, and he only arrested after recovering the items from the search.
Exactly.
We don't have any of that problematic testimony here. McKnight never testified that the only reason he arrested was because he only made the decision to arrest after finding the cocaine.
He was not asked.
He was not. He was not asked. That's correct. And the people do have the.
That's a burden failure, isn't it?
The people have the burden of going forward. This is actually echoed correctly by the suppression court's ruling. The people have the burden of going forward to show the legality of the police conduct, and that because this is a search warrant exception, that the reasonableness of the police conduct is there. But I think here, ultimately, the defense would have the ultimate burden of proving the illegality of the search.
You want to say you met the burden of going forward by the fact that they told him to get out of the car.
That they told him to get out of the car in conjunction with the fact that he recovered the marijuana. Yes.
Thank you.
Thank you.
Just a few brief points. First, to the extent.
What's your response to your friend's last statement? That they met their burden by showing that that the officers ordered the defendants as well as this defendant out of the vehicle, coupled with the marijuana.
Yeah, all that behavior, as I noted earlier, is perfectly consistent with an intent not to arrest. So that pointed to conduct.
Why are they collecting the marijuana then?
Why are they collecting the marijuana?
Yeah.
Well, because officers.
They're not arresting. Why are they collecting the marijuana?
Yeah, so it's actually not clear when exactly he collected the marijuana. Like, I think possibly what might have happened is the marijuana is found on his lap. If you're going to ask him to step out to then frisk him, well, before the marijuana falls off his legs when he stands up, you probably want to collect it. That's one possible reason. I think that is, this is like getting into speculation. But I will say, like, I agree that this.
So they were going to give it back to him? They were going to pick it up from the ground and say, "Here's you dropped your marijuana"?
Probably not. Like, honestly, suppose officers.
If they're not arresting, then the thing to do would be to just let it fall to the bottom of the car. But they didn't do that.
Well,
Counsel, I think there's a presumption that, do we know exactly when the marijuana was collected? Is it possible that it was collected after the cocaine was discovered and they made the decision that we're going to arrest? or was it recovered beforehand?
Yeah, it's unclear from the suppression record, which again goes to the extent the record is
Suppression
unclear.
record makes it seem like they may have gone back into the car after finding the cocaine to collect the marijuana.
Sorry, I didn't.
What testimony shows that they went back into the car after finding the cocaine to collect the marijuana?
Yeah, so there's no testimony on that point, but again, it's unclear from the record, which again hurts the prosecution, not us, because they're the one with the burden here. And so I agree, if this court believes there's some uncertainty, it might be in equipoise, I think the prosecution loses even in that case, because again, they're the one with the burden here and not us.
Thank you.
Thank you.
Thank you both. Where are you guys from? What school are you from? You're the teacher? The what school? Oh, welcome. Hopefully, you guys will learn something today. Attorneys, you're going to be on your best behavior, right? As I said, People v. Miguel Garcia.
Desiree Sheridan for Appellant Miguel Garcia. Your Honors, in this particular case, the indictment was jurisdictionally defective in that it failed to charge appellant with a crime. Consequently,
So it's obvious here that the including the word "with" is clearly a typographical error, right? He was charged all along that it's without consent. That's the gravamen of the offense. So what about that? It's a clear typographical error.
well, except that CPL 272 is very explicit that amendments to an indictment cannot be made if the indictment fails to charge a crime or state a crime. And here, the wording of this indictment stated that he acted with the complainant's consent. So that is not a charge, that's not a crime, that's not an offense.
Regardless of what was stated in the grand jury minutes?
Well, I would point out that actually the practice commentaries to CPL 270 actually state that even if the grand jury minutes say otherwise, if the indictment does not state a crime, you simply cannot amend it, and certainly you cannot amend it orally like what happened here.
And regardless of what stated in the felony complaint?
And also regardless of what's stated in the felony complaint. I mean, I don't think you can get around the four corners of CPL 272 because—
You're saying that because I think I think it's clear that what was presented to the grand jury, right, everything is on par with without consent. And what was written in the indictment is with consent. So if I'm hearing you correctly, what you're saying is, doesn't matter that it was a typographical error. It's jurisdictional, and that's it.
Yes, and also the statute indicated instances where you can correct a typographical error. So if you look at 271, it sets out the instances. In fact, I mean, it says that you can make an amendment with respect to defects, errors, or variances from the proof relating to matters of form, time, place, names of person, and the like.
Did you
and in
make
fact,
this
the court of—
jurisdictional argument below?
excuse me?
Did you make this jurisdictional argument below?
So below at the January 16th—
Isn't what happens when the judge tells you, that what the judge is going to do, you say, well, it's an objection, and then the judge says, well, I found that it's okay, and defense counsel says, okay. Isn't that basically what happened?
No, actually, defense counsel did not agree with this. So at the January 16th, the judge says—
But at the time of the plea, is he continuing with this objection at the time of the plea?
At the time of the plea, the judge had decided that they were rejecting defense counsel's objection, and so at the time of the plea, the judge said—
The judge says, I told you that I've amended it, the people amended it, and isn't what defense counsel basically says okay?
No, I don't think defense counsel did say okay, because defense counsel said they wanted to make a motion, and the judge said, well, I already decided this on January 16th, so the judge had made the decision.
Didn't defense counsel specifically respond okay?
She may have said okay after the judge told her, I've already decided it.
The court noted that it had previously found, based on a review of the grand jury minutes, that it was a typographical error, and wasn't defense counsel's response okay?
That was at the January 16th date. At the plea on May 24th, defense counsel states that she wants to file a motion, and then the judge comes back and says, I decided this on January 16th. It was over the defense objection.
And he was mistaken about that, right? That it was over the defense's objection.
The court?
Yes.
I don't believe so. I think if you look at the January 16th minutes, they approached the bench, and it looks like it was over defense objection because
Is that noted in the record, that defendant objected on the record?
in the record, the court says, I have a decision, and it says that there's a discussion at the bench, and then on the 24th, the judge says it was over the defense objection.
So I have that on January 16th, the court noted the people are going to have to amend the indictment to indicate that it was without consent. Neither party responded, and then the judge wrote 11618 and her initials, right? And then crossed out and inserted without, right? And then the plea is in May.
Right.
And the plea, at the time of the plea, the defendant does not appear to object. The court explained on that day that the people had orally amended the typographical error to add without. The court stated over the objection of the defense, and the court said that it had previously reviewed the grand jury minutes and that it was clearly a typographical error. Defense counsel responded, okay, and proceeded with the plea.
Right, because at that point, the judge had already made the decision, and there was really
You
nothing.
said that was on January 16th. In fact, that's at the plea, isn't it?
Well, the judge made the decision on the 16th and then told
But
defense
the
counsel on
okay
the
comes
24th.
before the plea on the day of the plea.
On the day of the plea, the court tells defense counsel, because there were two different defense counsels. So on the 24th, the court tells defense counsel, oh no, I've already decided this, I've already made this decision, and I decided it over the defense objection. So at that point, yes, defense counsel had no other option but to move forward and to file an appeal.
No, that's not correct. That at that time, the defense had the option of stating that the defendant was not going to plead guilty because there was a jurisdictional defect, and therefore they were not going to proceed with the plea. And by not doing so, the question is whether the defendant did in fact waive that right and whether or not this argument is preserved for appeal. You have time on rebuttal.
Good afternoon. May it please the court. Stephen Kress on behalf of the people.
Counsel, at the time of plea, did the defense object?
Not at the time of the plea, no.
All right, so when it's brought up at the time of sentencing, and the judge says, I've ruled on this, and it was over the defense objection, wouldn't it be reasonable then if defense counsel abandoned its argument thinking it's preserved, even if the judge was wrong and there was no objection?
I don't think so, Your Honor. I think...
So if the judge tells you, you already objected, we've gone through this, so the defense attorney has to do what? Argue with the judge and say, well, I'm objecting again?
Well,
you just told me it's preserved, or at least that's what I'm hearing.
Well, I think the problem here, Judge, is that there was no objection that was ever made on the record.
That's true, but the judge mistakenly said that there was an objection.
Well, there may have been an objection, so I don't think the judge was necessarily wrong. It may have been lodged in this off-the-record bench conference that happened on January 18th. It's just making an objection off the record.
It just seems a little unfair to me that you're trying to make the objection, you're shut down by the judge tells you the objection's already made, it turns out he's wrong, but now because you followed the judge's lead, now you're out holding the bag.
No, I understand that, Your Honor. I think ultimately it comes back to one of the purposes of the preservation rule, which is to make a record that's reviewable on appeal.
Right, so if I'm the defense attorney and you tell me, I already ruled on this over your objection, I would have to suppose that it was argued when I made the objection or when prior counsel made the objection.
But if there's no record to indicate that, I think you...
Well, that's presuming that you have the record right there for you and you're able to review that record about the appearance before. Here, the defense attorney took the judge at his word and he was mistaken.
Her word. But did it at any point in time, however, did the judge state that she was precluding the defense from articulating or expounding on what the exact objection was?
No, the judge did not preclude the defendant from making any of these arguments.
And actually, is there anything in the record where the statement is made as to exactly what the objection is, that based upon the statute or what have you, that you cannot orally amend?
No, I don't think there's anything setting out the basis of what the objection was. I think the only indication that we have that there was an objection is the judge's remark that she amended it over the defense objections.
Over the objection of the defense.
Right.
What is your response to your friend position, central position that this is a jurisdictional,
Right. So
as opposed to being typographical based on the totality of the record here.
Right. So I think this indictment is jurisdictionally sufficient because under this court's opinion in People versus Johnson, an obvious typographical error, which I think this clearly was, it does not negate the indictment's citation to the proper section of the penal law, which therefore satisfies 270 subsection 2A in stating an offense, and it doesn't negate the incorporation by reference of all of the elements of the offense, which would satisfy 270.
So penal law section 130, what is that, 53, I think?
Yes.
Yeah, 130, 53 specifically states contact without, sexual contact without the latter's consent.
Correct.
And the indictment obviously references that penal law section.
Correct.
And although it says with, that's your argument, obviously it's without.
Correct.
Can we look at the circumstances of the offense as well? We're talking about a subway car at 5:15 in the morning, and where he allegedly places his hand on the victim's leg, and I think then on I guess it's the number, I don't know if it's the number 2 train or what have you, at Times Square, where he allegedly slaps the complainant's buttocks?
So I think you can look at all of that in determining whether this, what was written in the accusatory part of the indictment was in fact a typographical error, and all of that supports that that's exactly what this
And then, of
was.
course, we have the grand jury minutes, and there was an inspection of the grand jury minutes by the court.
Exactly, yes. So I think all of those things together show that this was a typographical error, and under this court's precedent, that kind of error is not enough to negate the citation to the statute and the subsequent incorporation by reference of all of its elements.
Thank you.
Thank you.
So I just wanted to address the inclusion of the statute, and there was several third department cases, People versus Bula, People
This
versus
is the
Ferretti.
first. We're the first department.
I know.
Are there any first department cases which talk about that?
There are not, but this could be the first one.
This would be the first and the first.
So, but in those cases.
But what about the fact that we have an inspection of the grand jury minutes? And apparently the minutes, the testimony in the grand jury comports with the charges in the indictment. We also have the allegations in the felony complaint that was previously mentioned in terms of the circumstances of these 2 incidents. Why would it not be typographical?
Well, because first of all, unlike Terraberry, which my adversary cited, there's no spelling error here. There's nothing that makes the sentence.
With as opposed to without, they left out the out, O-U-T.
But the sentence with consent is grammatically correct and it makes sense. And there's nothing glaringly when you read with consent that makes it seem like there's an error. And
the statute talks about without sexual contact, without the latter's consent.
Right, but what they wrote was not an error. It's not a typographical error. There's no spelling problem, and I would submit this is not typographical because it made sense. It was grammatically correct, but it does not state a crime.
What about Johnson? Johnson talks about typographical errors. Johnson is our first department case, our precedent here. What about that? How do you distinguish the facts in Johnson or the holding in Johnson with this case?
Because in this case, when you read what's written in the indictment, it's just not a crime. It does not create a crime. It does not create a punishable offense, stating that you did something with the complainant's consent. It simply doesn't create any sort of a convictable offense, and that's the problem. And that's, I think, the problem, because if you read CPL 272, it doesn't carve out any exceptions for if the failure to state a crime in the indictment is the result of a typographical error. It says quite plainly, if it doesn't state a crime, it cannot be amended, the indictment. And it doesn't make any reference to the causes of why it's not stating a crime. It just plainly says that. And again, the Court of Appeals in People versus Perez, I think, is also offers instruction on it, because they came to the same conclusion, that if it does not state a crime, the indictment cannot be amended, and it doesn't provide any exceptions for why it's not stating a crime.
Thank you. Thank you both. McWashington versus AOD International. Yes, whenever you're ready.
Good afternoon, Your Honors. Michael DeRosa of Cozen O'Connor for Appellant AOD International. It is respectfully submitted that the court should modify the trial court's order by dismissing plaintiff's complaint, as plaintiff agreed to the terms of use, AOD's terms of use, when booking his accommodation at the Secrets Hotel in Cancun.
So essentially, it's your view that Section 12 of the Terms of Use controls, correct?
That is right.
That makes it very clear that you have nothing to do with the hotel.
That is exactly right. That is our argument,
And it
yes.
clearly states also, doesn't it make specific reference to personal injury claims?
It does. In Section 12, Your Honor, it does.
And this is a personal injury claim in that the the plaintiff states that he fell in the shower
In Cancun.
in
Right.
Cancun, the shower in the hotel, the Hyatt Hotel in Cancun.
That is exactly right. And the court is absolutely correct. That is the main crux of our argument. In order to book the hotel resort in Cancun, the plaintiff had to agree to these terms of use. The terms of use unambiguously state that AOD disclaims any sort of personal injury claims that are attributable to the accommodation itself. Here, that is exactly what occurred here. Plaintiff claims he fell in a shower in Cancun when he used the AOD website in order to book the accommodation. There's
So,
really
but
not.
the gist, one of the arguments is that this is subject to arbitration, and therefore it should be determined at arbitration as to whether or not this section applies to the plaintiff or not, or whether or not it applies to plaintiff or not.
Right, and I believe
a
that's.
viable claim.
I'm sorry, and I believe that's the crux of plaintiff's brief here. If I may, I just go through what the full portion of what the arbitration clause states, some of which was omitted in plaintiff's brief. It is broad. It states it's to be given the broadest interpretation and application to encompass all disputes or claims arising out of or relating to your relationship with AOD. Now, this is the part that was omitted. It continues, including the use of our website, our services, and any other interactions with us. Clearly, plaintiff falling at a shower in Cancun does not relate to the use of the website, does not relate to AOD services, and any other interactions with them. And if we think of just a sort of policy situation here, if anyone were to use AOD or Booking.com or any sort of other travel agency website in order to book their accommodation, they get injured there. How could that, platform, which all they are is the platform to facilitate this booking, why should they be held liable?
The only way you would arguably unhook would be some kind of misrepresentation in the website vis-a-vis the hotel you're booking.
Right, and that's
not at all alleged here at all.
I'm sorry?
That's not an allegation here in the underlying complaint.
Right, and that's not an allegation, and also there are other sections that are referenced in our papers, one of which is the Section 1A, right from the beginning, Scope of Services, where AOD disclaims any representation, warranty, or undertaking in relation to the quality, status, or adequacy of any accommodation listed on the site. Section 10, I'll continue, complaints. AOD outlines that complaints about the accommodation is ultimately a matter of the accommodation itself. And then there's also Section 13, miscellaneous. It explicitly states that AOD does not in any way own, manage, operate, or control the accommodations or any room in such accommodations, which runs counter to a primary allegation of plaintiff's complaint that AOD
Did I read that that however, if someone who had booked through AOD had an issue with the accommodations, that they should or could submit the complaint or what have you to AOD?
That is exactly right. And
within a certain period of time?
that's exactly right.
So would that perhaps lead one to believe that maybe AOD is, responsible for certain things?
Well, if they read the full portion of that arbitration agreement that I've read earlier, it's going to encompass all disputes or claims, including the use of the website, the services, and any other interactions with them. Plaintiff here had no interactions directly with AOD. He never sent them written notice of their claim as outlined in the terms of use, because once AOD gets that claim, then they have 60 days to resolve it, and if not, then plaintiff could have requested arbitration at that time. That was not seen here. Instead, a lawsuit was brought in New York County, a clearly improper venue.
Are you suggesting that if the plaintiff had in fact sent a complaint to AOD regarding the slip in the shower, that AOD would have focused on it or would have tried to resolve it?
They would have addressed it, and they would have, I would imagine that they would refer them to the entire terms of use and Section 12, which states that the limitation of liability for any personal injuries and the other sections that I referenced earlier as far as scope of services, complaints, and miscellaneous. And
Thank you.
thank you.
Hello, Don Worley for the respondent. I just want to briefly point out, I mean, they're asking for all the agreements that the consumer, the plaintiff in this case, allegedly agreed to on a website to be enforced. And if that's true, then they agreed to an arbitration clause. And according to the
But that presupposes that there's subject matter for the arbitration. And if your client signed to the terms of use, which makes it clear that they have no liability or responsibility for an accident in the hotel, what would be the point in going to arbitration, counsel?
Well, I think those are all fact issues about whether, because the consumer had no knowledge of any of this, and that's why we filed a lawsuit until they presented the arbitration clause and filed a motion with the court asking that the relief be the arbitration clause. We had no idea there even was one.
But they also moved to dismiss. I mean, it's like alternative.
Right, but there's a fact issue about where the plaintiff even agreed to all of those limitations.
Sir, what happened to Hyatt, the hotel owner? Why aren't they in the case?
They did not agree to the arbitration clause, and the arbitrator says you cannot bring in a third party that was not in contract for the arbitration.
I thought they weren't properly served.
No, they were, but they were dismissed for jurisdiction in New York. Agoda's here in New York, but they are not
Right,
hired.
there was no, right.
Your client clicks her acceptance of the terms of use. And when you use the website, you're agreeing to these terms.
Right, but didn't read all the terms and obviously didn't even know there was an arbitration
Well,
clause.
there are numerous cases as to that. There was one that just came down by the Court of Appeals a couple of weeks ago. But it's clear, you can't argue that although you clicked agree, that you didn't read it. That's not a viable argument.
But wouldn't that be that they agreed to arbitration as well? And the Supreme Court case AT&T in 1986 says that if the court shouldn't decide on the merits if there's an arbitration clause, and it should be sent to arbitration.
What you're asking the merits to be decided is something that you've agreed to have arbitration. But what happens in the shower in Mexico is not something that's covered by this arbitration clause.
Well, I would just argue that it's a fact issue, whether it's a contract of adhesion, and whether it should apply to this plaintiff or not. Thank you.
Anything on rebuttal?
The contract of adhesion point, we reference it in our reply brief, as outlined in Rivkin versus Brackman, First Department case 167 AD 2nd 239. An indication of gross negligence or unconscionability is needed to avoid the operation of limitation of liability clauses as seen here. There's no gross negligence here. There's no unconscionability. You have to click on you agree to the terms of use to use the website. If he didn't agree to the terms of use, he couldn't use the website, he couldn't make the booking, he couldn't go to Cancun, and I'll rest
Well,
on
you go
that.
to Cancun, you just couldn't do it through Agoda, that's all. You can always go to Cancun. But thank you.
Thank you, Your Honor.
Zurich American versus HBCU Holdings. Yes, you may proceed.
Good afternoon, Your Honors. May it please the Court, my name is Robert Spolzino, and I represent the appellant Zurich American Insurance Company. Arbitration awards are rarely set aside. We all know that. But this one should be, for several reasons. The first of which is the conduct of the umpire here. Whether you look at this under the Federal Arbitration Act and the evident partiality standard, or you look at it under the requirement that the umpire be disinterested under the...
How was the umpire an interested party? How was there any bias or interest on the part, to your detriment, on the part of the umpire?
He was part of a law firm. He joined a law firm that was representing...
Did he know this? Did he know the clients whom the law firm represented in conjunction with this case. Was he aware of that?
Well,
Well, let me put it in a different way. Is there anything in the record, did you submit anything showing that the umpire had any knowledge as to any clients clients of the firm he joined, which would be to your detriment?
well, the umpire said it himself. He said that he ran a conflict check. The conflict check would have had to reveal Zurich as an adverse party. Once he recognized that from the conflict check, he said the conflict check came up clear, but he couldn't have avoided that if he had actually run the conflict check and looked at it. The conflict check shows Zurich is an adverse party. He had a duty to investigate, and that duty to investigate would have led him to find that Zurich was litigating, or that Pillsbury was litigating against Zurich in a number of cases involving millions or billions of dollars on the exact same issue that he was being asked to decide.
And he said that there would be a wall so that he would not be privy to what was going on.
But a wall, I would submit, Your Honor, is not sufficient in these circumstances, and these are unique circumstances. This is not just that Pillsbury represented Zurich in some unrelated litigation or some minor litigation or some litigation that wasn't critical to Pillsbury. Here, Pillsbury was building a brand based on this litigation. The evidence in the record shows that. Their press releases and their documents showed that. Here comes the umpire, joins this firm where he knew or should have known for sure that they were involved in this litigation. The firm was involved in this litigation, and they were trying to make a brand out of it. And he is going to decide adversely to them in a case that's, he's going to make a decision that's going to destroy their argument. And
is there anything in the record that shows that any decision that the umpire, and first of all, he's not making these decisions alone. We're talking about 3 arbitrators, right? So he has 1 vote. But is there anything in the record to suggest that any decision or determination that he made in this case would impact the other cases?
Well, Judge, there aren't a lot of secrets in this business. And the word that he had made this decision would necessarily have gotten out and would have been a complete embarrassment to Pillsbury. And yes, he was.
That to me, that seems to be speculation. Also, you agreed to him to his being the umpire. Is that
Initially,
correct? Yeah.
before he advised anyone that he was joining Pillsbury. He was with Arnold and Porter
Yes.
until.
What was the timing of him advising everyone that he was joining Pillsbury? Was it an immediate notification, or was there a delay in that notification?
Well, he advised the parties on a Wednesday that he was joining Pillsbury on a Friday. Now, I don't think there's any reasonable argument that he decided on Wednesday and was joining Friday. I mean, these things just don't happen like that.
It's also not something you would announce before until it's actually done, right?
Right, but you would have, there would have been time leading up to it where
you
you
never
were.
can tell, things may fall apart, and you don't want that announced.
Correct, but it was not news certainly to him. He certainly didn't do the conflict check on Wednesday morning and let everybody know on Wednesday afternoon. So he had to know, and he had to, at that point, recognize that there was an absolute problem here in these unique circumstances.
Was he joining Pillsbury as a partner?
He's identified as a partner. The nature of the relationship is not clear from the record, but he's certainly identified as a partner in the law firm.
As I understand from the record, historically a different empire was chosen and then could not proceed because of a conflict.
That's correct.
And then he was chosen.
That's right.
And then in the process of that choice, he disclosed an earlier potential problem which you had no objection to.
One of the,
I believe the Arnold and Porter representing.
it involved one of the law firms. It was not the party.
Something along those lines.
Correct.
So everything was good, and now we have this situation where he's transitioning to Pillsbury, correct?
That's right.
And then within that short time frame, their disclosure, oh, by the way, the Pillsbury firm represents clients adverse to Zurich, and they disclose that, and he discusses the ethical wall, and he discusses that I'm not getting any financial remuneration from any of those cases, and that his remuneration was solely coming from this particular arbitration, correct?
It's not that detailed in the record, Your Honor. He said his remuneration did not depend on this case.
And had nothing to do with Pillsbury, right?
No, he's being remunerated by Pillsbury. He's being paid by Pillsbury.
No, but in terms of his being the umpire, had nothing to do with Pillsbury. Pillsbury was not going to in any way benefit from his serving as an arbitrator.
Was not going, well, it's not clear from the record if the money was going to Pillsbury and then to him, or just to
No,
him.
I thought I read in the record that he specifically stated that Pillsbury was not going to benefit in any way from his serving as an arbitrator.
I don't believe that referred to compensation, Your Honor. But I would say that there was an absolute tangible benefit to Pillsbury from his participation in this case, and even though he was only one, he was the deciding vote. This was a 2-to-1 arbitration. From his participation on behalf of HBC had a direct benefit. His finding in behalf of HBC potentially had a significant benefit to Pillsbury, or at least
How?
his finding the other way would have had a detriment.
How did it have a benefit to Pillsbury?
Because Pillsbury is building a brand, Your Honor, on its ability to successfully defend and get funds for these insureds. And now all of a sudden, one of its partners is saying, no, you're not right.
Litigation. That's in litigation, right?
There were litigations and arbitrations, but either way, he's,
Those are court cases, right?
there were some litigations and there were some arbitrations. So, but it was a broad thing. It was not one case. It was multiple cases where this was happening.
Well,
And then,
let's assume we can get past evident partiality, which I'm, arguably. Let's focus on whether there was manifest disregard of the law here. Here we have an arbitration decision where they've analyzed a phrase in the agreement, basically loss, damages, or destruction. And the question is how one interprets that particular phrase as to whether they can be covered for economic loss versus physical loss, correct? That's what really this all hinges on.
correct, Your Honor. But I think the manifest disregard goes beyond this is an interpretation of a contract and this is an arbitration, so we don't worry about that. It goes to the arbitrators and the majority of the arbitrators' failure to recognize roundabout, and in particular, the methodology that this court adopted in roundabout, which said you look at the insuring agreement and the perils insured against clause first. And those two here clearly require direct physical loss or damage. You don't just go to the provision in the middle of the policy. You have a policy that says this policy covers. And you can't have language later that just broadens that without saying so. This didn't say so. They have a whole argument built on inferences from various other provisions. But this policy covered only direct physical loss. And there was none here. No dispute that there was none here. If I may, in my last moment or two, go back to the disinterested requirement of the contract, of the arbitration clause. I would submit that that is a lesser standard than the evident partiality standard, and that under the disinterested, they were entitled by contract to a disinterested arbitrator. And whether it rises to the level of partial evident partiality or not, and I would submit that it does, whether or not it rises to that level, they certainly didn't get what they bargained for in this arbitration, or even what they initially had, which was a disinterested arbitrator that they agreed to. Once he became a partner at Pillsbury, and Pillsbury was representing Zurich, he was no longer a disinterested arbitrator, and Zurich was entitled to object, as they did immediately, and then have him removed from the case, or at least at this point, have the arbitration vacated.
Thank you.
Thank you.
Good afternoon, Your Honors. Brian Isaac. I represent the respondent. Seated to my right is David Godosky. He's the attorney of record for the claimant, and he's here to assist me with the argument. He assisted me with the brief. If it's all right with you, I want to invert my argument. I want to talk about manifest disregard first, because not only do we say that the insurance policy here was absolutely correctly interpreted syntactically, linguistically, verbally, and in terms of contract interpretation, but we have a manifest disregard standard that we both agree on. You have to have a precedent that's directly on point and that's disregarded for no good reason at all. It's almost like a due process claim. And
Well, he seems to suggest that roundabout was misinterpreted or ignored.
And Judge Weber, I'm glad you asked me that question, because that's exactly where I want to go. In the CRO case that you decided, okay, there's certain language that I want to focus on. And the reason I'm doing this is because I don't even think this is a legal argument. I think this is a straight logical argument. I've always believed that the strength of the New York judicial system is that judges and lawyers do everything on logical basis. Major premise, minor premise, conclusion draws from its fact. I'm a professional basketball player. You think I'm horrible. But in a court of law, the major premise is every player in the NBA is a great basketball player. Brian Isaac's in the NBA. Therefore, Brian Isaac's a great basketball player juridically. This is what you said in CRO, and I'm reading it verbatim. As more fully explained below, let me do the first part. The issue of whether business interruptions due to COVID-19 is caused by direct physical damage to property presents an issue of first impression for an appellate court in New York. That is word for word. It's not David Godosky. It's not Brian Isaac. That's you. Someone has to explain to me logically how you can have a manifest disregard of what you qualified as a first impression decision, and it gets better, when in fact the arbitrator's decision predated CRO by months. I submit to the court that that is a logical impossibility. It cannot happen. There's no way to fit it, there's no way to do it, and if you use logic, it's an impossibility. Now, the fact remains that the way the policy was interpreted is absolutely correct, because what we have here is we have a business interruption coverage, which by its terms does not incorporate a physical damage loss. And the general rule in contract interpretation, as you know, is that the specific always goes more than the physical. That's how you interpret the contract. This contract was interpreted syntactically absolutely the correct way. And in fact, I didn't realize this until actually Mr. Godosky told me, if you take Zurich's argument to its logical conclusion, it can't even be correct, because their argument is the insuring agreement says physical damage. Therefore, the only thing that's insured is physical damage in the property. What makes every single clause, including the perils insured against, superfluous, which is exactly what you don't do in an insurance policy. See my lights up, I'm gonna go quickly. Let me talk about evident partiality. There is none. And here's the one fact that Mr. Spolzino didn't tell you. It's a confidential proceeding. No one knows about it except HBC and the towers that are here. There is no benefit whatsoever.
Well, I think he would respond that there are no secrets, that it would have gotten out in terms of.
But it didn't get out. That's exactly the point. It didn't get out. It's 3 years post. There's no more COVID litigation. COVID litigation's at an end, and it didn't get out. The only people who know about it are people in this chain, and it has no precedential effect whatsoever.
What about the fact that Pillsbury was representing, although it's litigation, was representing Zurich?
It's a claim that is a logical claim, but there's no proof. And the case law, even the AIMCO case that they cite, says that you have to have actual proof of prejudice. The reason that we went into so much detail in our brief about what actually happened at the trial was because if you look at this trial, they got a better trial than we did. We disclosed 250,000 data points, 2,000 pages of documents. We disclosed our experts, the basis, how they were going to testify. We didn't get that. We lost ruling after ruling. This was an absolutely impartial trial, and look what happens.
Counsel, how do you respond to your adversary's position that the requirement in the contract that the umpire arbitrators be disinterested is a lesser standard than the evident impartiality, and that they've met that?
They haven't met it. I don't think it's a lesser standard at all. And
Please.
I'm sorry, I don't never go over my time. And in fact, there is no partiality here whatsoever. You know from the timing, there was no problem with respect to the umpire that was chosen that we're defending now. Originally, as a matter of fact, Your Honor, he represented Denton's, who represented Zurich. Nobody seemed to have a problem with that because that's what arbitrators do. And in his decision on 40 to 46 to 50, he cites the Second Circuit case, which says—
But he was at Arnold and Porter at the time.
He was at
wasn't
Arnold
he?
and Porter.
Yeah, but it's before he went to Pillsbury.
Sure, but he had no knowledge that this was transpiring at all. In fact, the first knowledge he had was when there was an objection, and the objection, just let me say this, the objection was not actually to him. It was to the fact that the process that they used to choose the arbitrators got skewed. Let's remember what happened. Each one point picks up an arbitrator, and then they choose a disinterested one. They couldn't agree. So what they did is they had a panel finding of 5, and what they did was actually pretty smart. Each party chose one from the other arbitrator. So we chose Judge Crane, right? They chose Judge Catterson. They did the coin flip, which was based on the Dow Jones Industrial. They won. For some reason, Judge Crane couldn't serve, so Catterson became the arbitrator. If you look at what happened after that, everyone was happy with what was transpiring until the first hearing, when Zurich argued for what essentially would be something like a trial. Long trial date, discovery, motions, etc. That was denied. Then suddenly you had a problem. If you look at the motion that they made, so I think it's 40 to 42 and 46 of the record, and I'll sit down, I'll stop talking because I'm not going to go over, look at the relief that they requested. They requested a stay, which they weren't having, and they didn't request that the umpire be taken out only. They requested that he be disqualified and that one of the individuals that they chose from their list should be appointed. That's not fair, and that's certainly not evident partiality.
So before you go, I want to take you back to what you started your argument with about the business interruption coverage. And I get your point about it doesn't mention in the business interruption coverage, it doesn't mention direct physical loss. But what does it mean when it says in that clause, covered herein? What is covered herein referring to?
Yes, so the exact phrase is, and let me just give it to you. It's
I think it's
covered
clause 7A,
here,
right?
yeah,
Clause
covered
7A.
covered herein during the term. What this arbitration panel did, and and I apologize for sending you the decision. It is long. I didn't write it, but they did the exact same thing. They said that that term does not refer to the policy generally, but only refers to the policies in 7A because there are 4 separate interests there which say covered herein during the term, exactly the same. They also
So their interpretation is that it doesn't go back to the insuring agreement, which appears at the beginning of the policy.
That's 100% our opinion, and it actually makes sense. And just let me give you the pages, if you can. If you look at 448B4A, and this is research and development, resumption of operation, and I'm quoting, it says, by a complete or partial resumption of operation of the property insured, whether damaged or not. Why would you have damaged or not if there's a physical damage clause incorporated into the full policy? And then you can go to 451 of the record, and that's going to be provision G, which is the period of recovery. Subdivision B says, quote, such additional length of time to restore the insured's business to the condition that would have existed had no loss occurred. Well, if you have a physical damage requirement, then subdivision A, which talks about physical repair, would be all that you would need. So the actual interpretation made in this case makes perfect sense syntactically, legally, and verbally. Thanks for listening.
Thank you.
Because, to answer your question, Justice Friedman, because there may be physical loss that wasn't physical damage. and therefore they wouldn't have had a claim if there's no physical damage. Once there's physical damage, there are other claims that go beyond that. I want to get back to roundabout. I heartily would suggest that covered herein has no reference to anything other than what the policy says, but other than what the insured agreement and the perils insured against clauses say. But
It's obviously your contention that it goes back to the insuring agreement.
right, because it has to, because the insurance agreement defines the universe of things that are covered, and the business interruption can't just add to that without some specific express statement of that. But I would go back, and that takes it back to roundabout, which says you look at the insured, the insurance agreement and the perils insured against to determine the coverage, the outer limits of the coverage. I would go back, I want to go back also, if I may, to the issue of the selection of the arbitrator. What the process that Mr. Isaac laid out establishes is that everybody had to consent. Both parties had to consent in each case. Yes, there was a drawing at the end by which they took they selected from among two acceptable candidates. But everybody had to agree, which is what happened the first time, that they were disinterested. The second time, when after Justice Catterson announced that he was joining Pillsbury, Zurich didn't consent. In fact, Zurich objected immediately to that. So if the process has to involve consent, which is what they established the first time, or recognition that the party was disinterested, the proposed arbitrator was disinterested, it had to do that the second time. And that implicates the disinterested requirement of the contract. And if it breaches the contract, the law is clear in New York that the party to the arbitration is entitled to the contract being enforced, which required a disinterested arbitrator here. Thank you, Your Honor.
I just one quick question, procedurally. Could they have stayed the arbitration to have this issue aired in a different form?
They tried. They brought it to this after going back and forth with Justice Catterson several times. When Justice Catterson absolutely refused to recuse himself, they went to Supreme Court, and Supreme Court said it didn't have any authority to remove the arbitrator in the middle of the arbitration. So that left the issue for resolution. They took an appeal from that. It wasn't perfected at the time because the arbitration was a month later. It was less than a month later, but it's brought up on this appeal, and the issue's raised.
Thank you.
Thank you, Your Honor.
People v. Pedro Gomez.
May it please the court, Elon Harpaz on behalf of appellant Pedro Gomez. Your Honors, the sentence here was illegal. Pedro Gomez went straight from being adjudicated a first violent felony offender to being sentenced as a persistent violent felony offender. Going directly from strike one to strike three is not the way the legislature intended the statute to work. Penal Law 70.08 is predicated on fair warning to the individual about the consequences of the repeat commission of violent felony offenses. That warning, as applied in thousands of cases, is done by successive adjudication. First violent felony offender, second violent felony offender, and then if that doesn't chasten the individual, finally persistent violent felony offender. That didn't happen here. Here, Pedro Gomez was resentenced as a first violent felony offender in Manhattan based on a then existing precedent of this court that held that the sequentiality timeline was reset and broken based upon—
Does People versus Carr figure into your analysis?
Yes, obviously that's a big question. That case was decided by this court back in 1997. In Carr, the defendant attempted to defraud the court and succeeded at first. The defendant gave an alias upon his arrest for his second violent felony offense and successfully was adjudicated only a first violent felony offender. When the fraud was uncovered after his arrest on the third violent felony offense, of course, the court was not going to let him benefit from that fraud.
But isn't what emerges from Carr, what matters here is the sequence of crimes and not the sequence of sentencing?
That was what I'm saying is that I think Carr got the right result, but for the wrong reason. I think Carr went beyond what it needed to decide. It should have simply decided, as in a myriad of cases, that no defendant can benefit from defrauding the court, and that's all that need to be decided.
But it wasn't, Carr didn't really speak specifically to what you refer to as a fraud on the court. Carr simply stated that you could still be adjudicated a second, that because you're adjudicated a second violent felony offender, you didn't have to be then adjudicated a persistent, the sequentiality. So your argument is that because for the second offense, he was adjudicated a first felony offender, right? Therefore, he could not have been adjudicated a persistent. But that's not what Carr says. Carr says exactly
And I'm
the
asking this
opposite.
court to limit Carr to the bad facts in that case because I think Carr got it wrong when it said, as a general rule, you don't have to be adjudicated a second violent felony offender. Let's remember, at the time of the resentencing in Manhattan in 2012, Pedro Gomez was no longer a second violent felony offender because he had no longer committed the two crimes in the proper sequence. And therefore, the fair warning he was given, which is what the statute requires, that's the key here. Whether there's an exception to the rule that you have to be adjudicated a second before you must have fair warning about the consequences of the next commission of a violent felony.
So Carr, leave was denied in Carr. So I know you're stating that it was bad law or what have you, or bad facts, but the Court of Appeals denied leave. And also, again, I think what is important is the adjudication. While he was not adjudicated as such, he was still a second violent felony offender.
No, based on Butler, this court's precedent, he was no longer a second violent felony offender.
Why?
He was a first violent felony offender because the PRS resentencing proceeding on the first violent felony offense occurred after the commission of the second violent felony offense.
He had still committed that violent felony offense, though.
He had committed two violent felony offenses, but not in the proper sequence, according to this court's decision in Butler. The fact that Butler was subsequently overturned 2 years later, almost 2 years later, by the Court of Appeals in Boyer, could not go back in time and give Pedro Gomez the warning that he did not have at the time of his resentencing. I want to suggest that in Carr, the defendant tried to trick the court. Here, in effect, the system is tricking Pedro Gomez because he was resentenced with the understanding, very clear at the time, that if he committed another violent felony offense, he faced adjudication as a second violent felony offender, and then, lo and behold, he was sentenced as a persistent.
So your argument is that at the time that he was sentenced in New York on the second case, he was not told that if you sustain a third violent felony conviction, you're a discretionary persistent and you could serve up to life.
He could not have been told that because it would not have been true.
So when would he have been told that? Could he have been told that?
So he could have been told that only by virtue of the Manhattan District Attorney's Office objecting to the resentencing proceeding on the grounds that it believed Butler was wrongly decided and expressing an intent to appeal. That never happened. They filed no papers in opposition, consented on the record, agreed resentencing was required, and took no appeal, no notice of appeal.
So again, your argument, therefore, is that a defendant has to be told at some point that if he or she sustains a third violent felony offense, he or she would be a discretionary persistent, and therefore life could be.
I'm not saying you have to be told. You have to be on constructive notice. You have to be on notice in some way, shape, or form. In this case, because of the resentencing, which was based on the fact he was no longer a second violent felony offender. That was out the window. That meant that the original warning he got back in 2006 when he was originally sentenced as a second VFO, that was gone. He was no longer a second violent felony offender. He could not have been warned by a decision that didn't come down until 2 years later that the Butler precedent was going to be overturned. That could not have served as warning. The only way he could have been put on notice constructively any which way is if the Manhattan DA's office had objected. They did not object. So I submit he cannot be found to be eligible for persistent violent felony offender sentencing unless there was a way to say, yes, he was on constructive notice in some fashion that a third violent felony offense conviction would subject him to sentencing as a persistent violent felony offender. Under the facts here, that simply was not the case.
Thank you.
Good afternoon, Your Honors. May it please the Court, Assistant District Attorney Saad Siddiqui on behalf of the Bronx County District Attorney's Office. Your Honors, the defendant's a persistent violent felony offender. He committed 4 violent robberies after his convictions for 3 prior violent robberies. He is convicted.
Was he given what your adversary describes as the required warnings?
Well, if we follow it just chronologically, 2001, he commits 2 robberies, or he pleads guilty. He's convicted of 2 counts of robbery in the first degree. He goes to state prison. He's released. 3 days later, upon being released, he goes and he commits another robbery. He gets convicted in New York County of attempted robbery in the second degree. At that time, he is sentenced as a second violent felony offender.
Is he told then that if you sustain a third, you will be discretionary?
We don't have a transcript of those proceedings, but operating under the presumption that everything proceeded as it should have, and at the time, statutorily, certainly the court was required to give him that warnings, and certainly the appellant has not raised that issue, or is not making any such claim that he was never given those advisals at that time. Presumably he was. So now we go to the...
Wasn't he resentenced on that ultimately?
Ultimately, yes, in 2012.
What does that do to those warnings if in fact they were given?
Well, I understand the court's point, and I understand counsel's point, and that was based on the precedent set by this court in People v. Butler, but that was subsequently overruled by Boyer. Notwithstanding the fact that by the time this defendant committed the 3rd series of violent felonies, he had already been convicted and sentenced on 2 separate violent felonies. So certainly the plain language of the statute, Penal Law 70.08, specifically speaks to that. It requires that a defendant be convicted and sentenced, then be convicted and sentenced again. And the legislative intent is clear. It's even looking at the Court of Appeals holding in People v. Morse, where the legislative intent was to ensure that someone would be convicted and sentenced, and upon serving their sentence, if they go out and they commit another crime, another violent felony, and get convicted and sentenced again, and then convict a subsequent 3rd violent felony, they have failed to address their conduct, they have failed to abide by the laws of society, and that is why the sentences escalate to the point where you are a persistent violent felony offender. And at this point, looking at the chronology, factual chronology of this case, the defendant within a 10-year period, factoring the tolling period for the time the defendant was incarcerated, which was quite a lengthy period of time in between all of these convictions, he was convicted sequentially in 2001, in 2006, and then again in 2013.
But in 2006, he's not sentenced as a second. He's sentenced as a first.
No, in 2006 in New York County, he was initially sentenced as a...
And then he was...
He was resentenced on that.
As a first.
As a first.
Okay, so now, again, the statute talks about chronological and or receiving notice. So in his mind now, if all of a sudden now I'm a first violent felony offender, that means that my next one is going to be a second violent felony offender, right?
But notwithstanding all of that, you go back to the language of People v. Carr. This court's holding in 1997. Again, looking at what the requirements were, he does not have to be adjudicated a second violent felony offender, and this was this court's own analysis.
Don't we need to notice to the defendant that you could be sentenced as a discretionary persistent?
But it's not, the issue isn't about discretionary persistent. The issue is about persistent violent, which is a completely different standard.
Don't we need to notice to the defendant that he could be sentenced as a persistent?
Well, certainly not according to the language of Carr. Carr doesn't speak to that, because if there's no requirement that the defendant be adjudicated a second violent felony offender, then there's no notice requirement as opined by the precedent of this court.
And Carr does not talk about notice.
No, Carr does not. In fact, I would read the specific language of Carr. Defendant contends, and this is the defendant in Carr, that the court erred in sentencing him as a persistent violent felony offender since he was not sentenced as a second violent felony offender. Again, by implication, speaking to the notice issue that counsel is raising, for the second underlying violent felony conviction that formed the basis of the adjudication, citing to Penal Law 70.04, 70.08. However, since defendant stood convicted of a violent felony, had previously been convicted of 2 violent felonies, in that he had committed the second violent felony offense after he had been sentenced for the first one, and had committed his third violent felony offense after he had been sentenced for the first 2, he was properly sentenced.
Counsel, you concede then that because he was never officially sentenced as a second violent offender, that he never got the warning that should there be a third, you face a life imprisonment.
Well, certainly at the time, and as the sentencing court, the initial plea that the defendant took on the underlying case, yes, the trial court, Judge Clancy, was bound by this court's precedent in People v. Butler. But again, subsequent to the Court of Appeals decision in Boyer, my office, the Bronx County District Attorney's Office, made the motion under CPL 44040 to have the defendant resentenced. And then subsequently, Judge Clancy, relying on the Court of Appeals analysis in Boyer, vacated the defendant's plea and allowed him to replead, at which point he was sentenced as a persistent violent felony offender. And I might add that the trial court felt it was certainly bound by the statute. And while concessions notwithstanding, what is very clear is that, again, this court's decision in Carr is controlling.
And when he takes that plea, he knows he's going to be sentenced as a persistent.
Well, certainly at that point in time when he took the second, after the vacature of the plea, and then he repled in 2015, certainly he was given that advice. There was a lengthy period, there was a protracted period of litigation because the people had filed the motion, the defendant did have an opportunity to respond, he was produced, and at the time he was serving a sentence as a second violent felony offender. Judge Clancy, the trial court, did issue a written decision to which that the trial court felt it was bound by the Court of Appeals decision in Boyer, which overruled this court's decision in Butler. And then following the analysis between Boyer and Carr, it was very clear that the defendant had to be adjudicated a persistent violent felony offender. And I would note, and I did provide a copy to counsel, I did add a supplemental reference in that copies were provided to the court this morning, and I apologize for the last-minute submission, but the Eastern District Court of New York has also relied on this court's analysis in People v. Carr in a similar case in which a defendant was convicted in 1981 of a robbery, and then in 1988, that defendant, and this was a habeas petition, was convicted of a second robbery in 1988, but the court in that case did not sentence the defendant as a second violent felony offender. The defendant got no notice on the 1998 conviction. Subsequently, in 2002, that defendant went to trial and was convicted of a burglary in the second degree conviction after trial. The trial judge sentenced the defendant as a persistent violent felony offender, notwithstanding the fact that the defendant had never previously been sentenced as a second violent felony offender, and the trial judge relied on this court's analysis in People v. Carr, and the Eastern District, relying on this court's analysis, upheld that on a habeas petition.
Thank you.
Thank you, Your Honors.
Your Honors, when Pedro Gomez was resentenced in New York County in 2012, he became a first violent felony offender. The constructive notice he was on was that should he commit another violent felony offense, he would be subject to sentencing as a second violent felony offender. That is exactly what happened, because originally Judge Clancy sentenced him as a second violent felony offender for the Bronx County offenses and warned him in the event of another commission of a violent felony offense, he would be subject to sentencing as a persistent violent felony offender. That is the only notice and fair warning that he had at the time.
So under your theory, under your argument, therefore, a defendant could have 3 felony convictions, and the next felony conviction, if he's sentenced as a first, he starts all over again.
No, if sequentiality is correct, then that won't happen. In other words, I'm not saying that. It's interesting that my adversary brought up the federal habeas case, because there you could say effectively there was a mistake made, but effectively that defendant should have been on notice.
Okay, so under your theory now, he's a second violent felony offender. So now if he sustains there's another round of litigation, he's declared a first violent felony offender, and then he's going to start all over again?
Well, I don't know on what basis he would be declared a first violent felony offender unless the entire sequentiality was again undone. Obviously, now we're asking for him for the original sentence that Judge Clancy imposed in 2013 to be reinstated, 17 years plus 5 years PRS instead of the current sentence of 20 years to life, that be reinstated as a second violent felony offender. And obviously, if he commits, when he gets out, another violent felony offense, that would surely expose him to being sentenced as a persistent violent felony offender. Simply saying, right now, as it stands, because the statute is predicated on fair warning, as the Court of Appeals made crystal clear in both Morse and in Boyer, he did not have that fair warning. And there's no way to tease it out from either the original sentencing, because that was undone, or from 2 years afterward, because he couldn't have had notice of something he didn't know about at the time, or from a warning he never got from the Manhattan DA's office.
Thank you. Thank you both. Gibraltar Contracting v. Tully Construction.
Good afternoon, Your Honors. May it please the Court. My name is Donna Mazza on behalf of Defendant Appellant Tully Construction. The lower court erred when it denied Defendant Appellant's motion to dismiss. First, the lower court misapprehended the plain language of the Defendant Appellant's certificate of final completion as it pertained to the shortened 6-month statute of limitations contained in paragraph 32 of the subcontract agreement between the parties. The certificate is, in fact, a final acceptance of work by the owner. It is an executed, self-authenticating document pursuant to CPLR 4540 because it is an official record of a government office, which in this case is the Triborough Bridge and Tunnel Authority. We believe the court was confused with the 4 signatures of the TBTA employees. The 3 signatures were dated 8/31/21 and recommended acceptance of the work by the owner. The 4th signature was the approval of the staff's recommendation by the chief engineer and vice president.
How do we know that?
Because it says it on the document, Your Honor. If you look at the project manager, Timothy.
But how do we know that that constitutes a certificate of completion?
Because.
A final completion?
Because they're recommending it, the 3.
But it doesn't say on the document that it's a certificate of final completion.
It said certificate of final completion on the document.
It says that he's recommending it.
Right, they're recommending it, and then the resident engineer of the TBTA, Timothy Kellen Bray, and the project manager, Timothy Kellen Bray, and Earl Wilcott, the resident engineer, along with Mr. Bray, who signed on behalf of the deputy chief engineer, Romulo DeSantis, all are TBTA employees. And they're recommending approval on August 30th, 2021.
Would their recommendation necessarily carry? I mean, it's a recommendation.
Well,
could it not have been rejected?
No, because then on September 9th, 2021, at 7:29 a.m., the Vice President and Chief Engineer, Joe Keene, approved those recommendations and electronically stamped.
That's the part that I'm missing. How do you conclude that he approved it? Isn't he just signing off along with the other three that this is his recommendation as well?
No, because they signed it on August 30th.
So there's a difference in the date that so three signed it beforehand, one signed it later. Does that mean that the later one carries the weight?
Well, Your Honor, I mean, we requested from the lower court a re-argument because we received an affidavit from the TBTA saying that this was the only document that they submitted to Tully for the recommendation that it was, and it was a final acceptance of the work by the owner, but the court refused to hear our re-argument. So we do have an affidavit.
So what does the September 9th, what's underneath the September 9th signature?
The September 9th signature means that the chief engineer approved the recommendation of his fellow employees.
No, counsel, if I could not, I don't want to know your interpretation. What does it say underneath?
It says confirmed, doesn't it?
I'm sorry, say that again.
What does it say underneath? Does it say approved or something else?
It doesn't say approved physically, but obviously he's the chief engineer. He has the sign off of the document. And this was the only document. I have an affidavit here from the TBTA, from Joe Keene, saying that this is
that doors the record, right?
Excuse me?
That's not part of the record?
No, Your Honor. I tried to.
Right. Thank you.
But that signature doesn't say that it's, does it say it's approved?
Well, Your Honor, this is their official document.
But the question is, does it say approved? It does not say approved.
The fact that it has his name and it's electronically stamped to the second, to the date and the second, is the final certificate of acceptance by the owner.
Thank you.
Can I speak further about the other causes of action? or-
No, that's about it. But thank you
Okay,
so much
thank
for
you, Your
coming.
Honor.
Appreciate it. Mahia v. St. Barnabas Hospital. Justice Rodriguez is recused on this matter. Should there be a tie, as per the rules of our court, another judge will be vouched.
Good afternoon, Your Honors. My name is Daniel Murphy on behalf of the appellant. There's really only one question on this appeal, which is whether or not the defendants raised a tribal issue of fact on the issue of loss of chance. Now, the court below, in relying upon that expert's opinion, didn't go to the substance of the opinion, did not address whether or not it was a conclusory speculative opinion.
So are we talking about Dr. Rose?
The defendant expert is Dr. Buckner.
Okay, so we have Dr. Buckner's opinion, right? And what does Dr. Buckner say?
It's more a question of what he does not say, Your Honor. So on the issue of loss of chance, Dr. Rose gives a detailed explanation of why he says that the dislocation should have been reduced at the latest 7 to 10
Right, so
days.
Dr. Rose says this, but Dr. Rose waited 2 months before actually conducting the partial reduction, right? Wherein Dr. Rose says it should have been done within 7 to 10 days. He himself waits 2 months before the actual reduction.
By the time he has seen the plaintiff, he's already substantially beyond that window. It's about a month or more later. And even if we were to raise the point that Dr. Rose somehow contributed to this, we need to show that the defendants are a proximate cause, not the sole proximate cause.
Didn't Dr. Rose see the plaintiff in June?
June 5th of that year.
June 5th, and that's when he took an x-ray and he examined the x-ray and concluded
That was
he
the
had
first
these
time
injuries.
that the dislocation had been correctly identified, correct?
Right, so then when did the surgery take place?
I believe it was in August of that year.
In August. How many months went by? Almost 2 months?
Correct. But again,
So if he says that in order to prevent any damage from occurring, this condition needs to be addressed immediately, within 7 to 10 days, and then he takes 2 months almost to address the condition?
he states that if it's not done within 7 to 10 days, the window has closed and irreversible damage has occurred, and it is no longer possible to restore full function. So that has already occurred during the plaintiff's time with St. Barnabas.
And what waiting 2 months is not going to make, so according to Dr. Rose, then waiting an additional 2 months is not going to make a difference in terms of treatment of the thumb or the thumb regaining use or partial use of the thumb.
That's his opinion. And even if it's not accepted, ultimately that's a secondary issue. Again, we need only show that St. Barnabas were a proximate cause, not the proximate cause.
I don't know if it's a question of one or more proximate causes, but I think the issue here is you have one expert, Dr. Buckner, who basically says that immediately upon the thumb being dislocated, it affects the blood supply from the get-go. So therefore, the damage is done right then and there, so that essentially it was his opinion that there will be no change in the outcome regardless of when the reduction is performed. That's an opinion of that expert. On the other hand, Dr. Rose said, no, something should have been done sooner.
Well,
So bear with me for a second. So we're dealing with dueling expert affirmations, which is the classic basis for a trial fact for a jury to resolve, no?
Well, I would submit, Your Honor, that it's actually a classic case of a conclusory opinion, and it's well within the criteria of what this court regularly sets aside and does not find a triable issue of fact for the following reasons. When Dr. Rose says that it should have been done 7 or no later than 10 days, he offers a detailed explanation supported by medical literature as to 4 mechanisms which are acting. Okay, so we have not just the blood supply, we also have ligament contraction, irreversible cartilage damage, and soft tissue and bone interposition. Okay, now Dr. Buckner does not even acknowledge 3 of those. All right, and even as to the issue of the blood supply, he does not engage with Dr. Rose's opinion. He does not disagree with the medical literature which is cited, nor does he cite literature of his own. But I think most importantly, he does not even reference 3 of the 4 factors. So you cannot have a partially non-conclusory opinion. He is not addressing the specific assertion of Dr. Rose. Therefore, it is a conclusory opinion on his part.
Why is he not addressing the specific statements by Dr. Rose, wherein, as my colleague just stated, Dr. Buckner says that upon the dislocation, it's going to be divested of blood supply. Therefore, there's not going to be any change of outcome regardless of when the reduction is performed.
Well, as to blood supply, but he doesn't go on to add, we would have to infer that he is somehow saying that that's so desperate that that would supersede the other 3 mechanisms. If that's what he wanted to say, he should have written it. He did not write that. He only addresses blood supply. He does not reference the other 3 factors whatsoever. If there's no further questions from the court, I'll leave it at that. I do think that loss of chance is the sole issue, and given that there are admissions regarding departure and there is no evidence nor any basis to say that it did not ultimately need to be reduced, it's a question of that 7-day window.
Thank you.
Good afternoon. May it please the court. My name is Samantha Quinn. I represent the defendants, respondents. As Justice Shulman pointed out, this is a classic case of a battle of the experts. And in fact, Dr. Buckner's comment that the blood supply would be divested immediately upon the injury does speak to the remaining 3 points mentioned by Dr. Rose, because the divesting of the blood supply causes contraction of ligaments, irreversible damage to cartilage, and soft tissue injuries. Additionally, Dr. Buckner actually examined this patient on October 11th of 2021, nearly 3.5 years after the injury. He concluded that he had a normal orthopedic exam, but for the scar, no significant clinical findings and minimal permanency. That in and of itself is an expert disagreement. Dr. Rose says that there was persistence and worsening of the patient's symptoms for 5 years. Our examining physician said that there were no significant clinical findings of minimal permanence. That's not addressed by the plaintiff. Additionally, the plaintiff seems to misconstrue the standard on summary judgment opposition. The evidence has to be viewed in the light most favorable to the party opposing the motion, and that is the defendant in this case. They must be given the benefit of every favorable inference. So therefore, they had to acknowledge that exam, which said 3.5 years later, there was no discernible injury. And Another issue is the ultimate sufficiency of Dr. Rose's affirmation in the first place, because he refused to acknowledge or failed to acknowledge the patient's own noncompliance. And for example, he removed the splint multiple times.
But wouldn't that go to comparative, really?
Well, it may, except for one thing, Your Honor. On the 5/16 visit, he was told to get an MRI. Now, if he had, that was 7 days after the injury. If he had followed that direction, then this could have been diagnosed within that window that Dr. Rose talks about. And in fact, he came back 5 days later and was again told to get an MRI. And this is, excuse me, the record at page 206. He presented to the clinic without an appointment to request a return to work note. He had removed his splint. He had not yet obtained the MRI. The doctor from St. Barnabas was unable to provide clearance for return to work without the MRI. Patient was advised to be placed back in his splint and to obtain MRI, and the patient declined. The failure of the plaintiff and the plaintiff's expert to address how this could have possibly impacted his condition is a fatal flaw, and I see that my time is running out, so I will rest on my brief.
Thank you.
As to counsel's first point regarding the blood supply, she goes on to state that the total divestment of the blood supply would cause the other three factors. That's a statement by counsel. It's not a statement by her expert. It's not contained anywhere within the record. Again, if Dr. Buckner wanted to offer that, he had to say it. He can't ask this court to infer substance to his opinion where there is none. As to the issue of the MRI, he was referred for an MRI on the 16th of May, okay, which would be 7 days out. However, he was referred for an MRI, it's on record, page number 205. It was a non-emergent priority. He was not told to get an MRI that day. He was not offered one that day, and he refused it. He was told to come back 2 weeks later, which would again put him substantially outside of that window. As to the independent medical exam, counsel offered a lot of details there about it that I'm familiar with, having received an IME report. I don't see the IME report in the record. In the affirmation, all he says is, I saw him 3 years, for one time, 3 years after the incident. He says that he found no significant findings, but he also said he found a minimal permanency. So he doesn't discuss what the plaintiff's complaints were on that date. He doesn't discuss what form of exam he did and what the results of that were. And clearly, if there's non-significant findings but minimal permanency, he found something. What he found, we don't know. Nor does he address at any point the fact that Dr. Rose saw the plaintiff for 3 years up until that point and was documenting range of motion, strength deficits, and so on, and then saw Dr. Rose for another 2 years after that point, up until the time of the motion practice, and again continued to find range of motion deficits, swelling, loss of strength, and so on. Now, counsel also just finally referenced the idea that every inference must be given in favor of the opponent. However, this court on almost a weekly basis is dealing with medical malpractice motions, okay? The only novelty here is that it's a plaintiff bringing the motion. This court routinely looks to the substance of an expert's opinion and determines whether or not it's conclusory or speculative. And the definition of that consistently is where the opposing expert does not adequately refute the opinions of the movements expert. And here, where they clearly failed to address 3 out of 4 factors, of course they have. And if I could just finish on...
Oh, that's it, but thank you so much.
Thank you.
U.S. Bank v. EquiFirst Corp. Yes, you may proceed.
Your Honors, Jeff Scott from Sullivan and Cromwell on behalf of EquiFirst and Barclays may please the court. For approximately a decade, state and federal courts in New York have debated the scope and viability of failure to notify claims such as they are in RMBS cases. The first case that's relevant here obviously is Ace Securities. In 2015, that case found that the second step, procedural step of the repurchase protocol, the repurchase obligation, did not provide an independent cause of action if it was breached. The Court of Appeals held that the repurchase protocol provides a remedy, not a cause of action. It's procedural in nature, and it needs to be invoked and followed in order to obtain the remedy. And all three steps with them were procedural in nature. This court in Nomura in 2015, and then in Morgan Stanley in 2016, did find that there was an independent cause of action for failure to follow the notice provision, which is the first step of the repurchase protocol. Subsequent to that, in 2019, the Court of Appeals again interpreted the repurchase protocol. And in that decision, that court found, and I just want to read it because I think it's dispositive here, and this is U.S. Bank versus DLJ 33 NY 3rd 72. And it was reaffirming this holding in Ace from the Court of Appeals. It says RMBS notice and sole remedy provisions are not substantive elements of the cause of action, but, quote, a procedural requisite to suit. And this court, since that decision in 2019 from the Court of Appeals, has not had the opportunity to address the scope of a failure to notify claim where the defendant is actually a party to a repurchase protocol. Judge Weber, you were on a case, In Re Part 60 RMBS, and that's at 195 83rd 40. In that case, the defendant there said, well, there's no independent cause of action for breach of contract for violating the notice provision. But this panel that Judge Weber, you were on, Justice Weber, you were on, the panel noted that the party there was not subject to the repurchase protocol. And it said, however, if it were subject to the repurchase protocol, you would have a persuasive argument that the first step, the notice provision, was a procedural condition precedent, and there'd be no independent cause of action. And what In Re Part 60 actually cited was the DLJ case, but it couldn't actually issue an opinion there because it didn't have a party subject to the repurchase protocol. Justice Crane last year, and I have the case here, Justice Crane in HSBC Bank USA versus Nomura Credit and Capital, and that's at 2023 Westlaw 636-8033, she said there is conflicting case law in the state of New York as to whether a party can maintain an independent cause of action based on a failure to notify. And lo and behold, she cited the U.S. Bank versus DLJ case. That was the same case that the First Department cited in Re Part 60, and she cited the conflict between that Court of Appeals case, DLJ, and this court's original decision in Nomura 2015. I think if the panel of this court in Nomura and Morgan Stanley had the additional guidance from the Court of Appeals in DLJ, it would have found that all three steps of the repurchase protocol are interlocking in nature. The Court of Appeals has said it's procedural in nature and doesn't, in the words of the Court of Appeals, provide a substantive cause of action. As a result of that, there can't be a cause of action for failure to notify in this case. EquiFirst, no one disputes, is a party to the repurchase protocol. It's a sole remedy, and the only remedy here is either repurchase or repurchase damages or cure. That claim, a claim for a breach of rep and warranty, is now time barred. So what they did when they lost that below U.S. Bank.
You make the argument that they just retooled it as the failure to give notice here.
Yes, absolutely. And in the three other sole remedy cases that we cite, and those cases are at pages 6 to 7 of our opening brief, those cases are the AMBAC case, the DLJ case, and what they hold is It's a sole remedy, and it's strict, and it's the only remedy, and you can't restyle other claims. For example, a gross negligence claim, right, where they tried to evade the repurchase protocol. And what the Court of Appeals said when it finally got to them is that, no, that's not right. It's a sole remedy, and there might be gross negligence, but that doesn't avoid these type of limitation of liability provisions. And so they actually, and this is interesting, the Morgan Stanley decision from 2016 that found the failure to notify claim also found that gross negligence allegations would have helped you evade the sole remedy of the repurchase protocol. But years later, when it made its way finally to the Court of Appeals, the Court of Appeals said, no, we meant what we said. When you have a sole remedy, you can't use gross negligence to get around it. I think if this type of case ever makes it to the Court of Appeals again, they're going to say the same thing, which is, no, what we said in ACE Securities and what we also said in DLJ is that the repurchase protocol is procedural in nature. It doesn't provide a substantive cause of action. And when a party is subject to the repurchase protocol, there is no independent cause of action. I see my time is up, and I'll thank you, Your Honor.
May it please the court, Neil Lieberman on behalf of the respondent, U.S. Bank. Appellants are asking this court.
Is it true that we have held that a failure to notify gives rise to an independent breach of contract cause of action? But doesn't that cause of action disappear, if you will, where there is a repurchase obligation under the mortgage loan purchase agreement? And wasn't there such an obligation? Didn't EquiFirst have such an obligation?
It did have an obligation. That obligation, the failure to notify does not disappear. And I don't think it's a fair reading of this court's precedents to decide to characterize it as the failure to notify disappearing. In each of the times the court has addressed a failure to notify, it has styled it as an independent obligation. And it's done so from the beginning in the shadow of ACE. ACE was decided before the first failure to notify case. The Nomura case was decided shortly after ACE. This court granted leave to appeal the Nomura decision to the Court of Appeals, and the remit to the Court of Appeals was broad. Was this decision properly decided? And the Court of Appeals acknowledged that there was a failure to notify claim that this court recognized, but did not modify that aspect of the decision. So the idea that now there are these subsequent decisions, that there's a extenuating circumstance that should cause this court to depart from its 10-year precedent doesn't make sense. I'd also highlight the LDIR case from 2019 that we cite in our papers, where this court recognized a party that had no live R&W claims, was seeking to hold a party with a repurchase obligation responsible for a failure to notify.
But in LDIR, the notice provision, I thought we said was ambiguous. And so the notice provision in this instance is not ambiguous.
Correct. So that's even a clearer case that in this case that the claim is viable. But you granted leave to amend, and one of the preconditions of a leave to amend is whether there's futility. If this court thought that ACE barred claims, failure to notify claims against responsible parties in RMBS cases, then it surely would not have reversed the trial court and allowed LDIR to amend its complaint to add those claims. And that's 2019 after the DLJ decision that my adversary just cited.
Counsel, you agree that you were time barred from being able to sustain a claim for the breaches of the representation and warranties of the underlying mortgages in the origination process. You agree to that?
We do not have a breach of R&W claim. That's
right. So a breach of R&W is essentially that the mortgages were flawed. So isn't that the same as failure to notify? The same mortgages are flawed?
No, this is the difference. When the Court of Appeals in ACE held that the R&Ws were made at the time and the mortgages were flawed and there was no promise of future performance, and that's the remedy. The remedy for the breaches was repurchase. Here there's, and this is what the First Department has continued to hold. There is a promise of future performance. The promise of the future performance is to notify the trustee when there's a breach. And so it's related, but it is not, it's consistent with ACE, and so that's, so it, well, I was just saying, it's consistent with ACE in the sense that it is a promise of future performance, unlike the repurchase. If I could move on just briefly to another point about this. There's a complaint in the papers that this will open up the statute of limitations to some unending liability. That's not the case. As these cases have been litigated in the trial courts, one thing that's been made clear is that the statute of limitations remains the same. We have a claim for a failure to notify, but we can only seek damages within that 6-year ACE window. So although there's a window for us to seek damages is limited to when they would have notified us, but for the lack of notifications, we would have been able to get repurchase. So there's no unending, this parade of horribles, that there's unending liability throughout the life of the trust. Just it isn't so. And I would just say on a couple other points, there's several attacks on our pleading. The pleading standard is a notice pleading standard as to both the allegations that that EquiFirst discovered breaches, and also as to Barclays' alter ego liability. We met those under the notice pleading standard.
Thank you.
I did have,
Sorry, go ahead.
you know, when you turn to Bank of New York Mellon, so at the end of the decision, it says, this holding does not bar JPM Bank's obligation as servicer because the service is not subject to the repurchase protocol at all. It's towards the end of the decision. I hate to hit you with just one sentence out of the decision and ask you a question. What does that mean? How does that fit into the point you're making? If you'd like, I'll repeat the sentence.
Well, it's an additional reason, because before that, it recognizes that decision recognizes, and the subsequent INRI Part 60 decision also recognizes that there is an independent cause of action for failure to notify.
So then it goes on, as a result, because JPM Bank has no obligation under the repurchase protocol, that protocol cannot bar a cause of action against it for an independent duty to notify. The converse of that is that if it was under such an obligation, it would bar a cause of action for an independent duty to notify.
I don't think it's a limitation on that.
It's the last sentence before you get to the accordingly.
Right.
Actually, the decree. It was the last sentence of, I think it's Judge Moskowitz's opinion. How does that sentence jive with the point you're making today?
Well, because it's an additional reason why a party like JP Morgan might have, why you might reject this argument as to JP Morgan, but it doesn't limit the overall independent obligation to notify of any party in these circumstances, which was reaffirmed after this in LDIR, for example. And there's no other limitation on Nomura or Morgan Stanley. So there's no basis to do that. The thing that I would point out is that when we talk about DLJ and the DLJ decisions at the Court of Appeals, they are talking about enforcing notice provisions in the contract. Now, those cases are about enforcing notice provisions as to the trustee. So the trustee wasn't, where the trustee did not fulfill its notice obligations under the contracts, they were barred from bringing claims. What we're asking here is that a responsible party with a notice obligation, which this court has recognized for over 10 years, or for almost 10 years, is an independent obligation, also be held to the same standard. That's all we're saying. These contracts have meaning, and there's a notification obligation in the contract, and the failure to notify is an independent actionable claim under them.
Thank you.
Just very quickly, Your Honors. The first thing I'll say, which I'll just reiterate, is that Nomura and Morgan Stanley in 2015 and 2016 did not have the benefit of the DLJ opinion from 2019, which was very clear in its language. The LDIR case, the Natixis case, and the Greenpoint case, all cases they rely on, also didn't address the scope of a failure to notify claim in light of DLJ. It just simply assumed that there was an independent cause of action for failure to notify. The question about the relevant promise here, the relevant promise here is not a promise to give notice in the future. What the court said in ACE is did the defendant make a promise like was made in the Bulova Watch case to somehow repair in the future or to guarantee the performance of these loans in the future? And EquiFirst here, just like the defendant in the ACE case, never made a promise as to the future performance of the loans. All they did was made reps and warranties at the time of the closing of the securitization. And every case in the First Department and in the Court of Appeals that addressed that question said that's the relevant breach date, right, the time of closing. The last thing I would say is, yes, there could potentially be a parade of horribles if there is a failure to notify claim that goes beyond the 6-year statute of limitations, right, that was set forth in ACE securities, because mortgages are commonly 30 years. They could be in a securitization vehicle for 30 years. And if there is such a thing called a failure to notify claim against a party to a repurchase protocol, even though the underlying breach of rep and warranty claim has expired, they could be exposed to litigation cost and expense through failure to notify cases for an additional 24 years. And of course, there's a whole long line of Court of Appeals cases and First Department cases which said that New York State likes predictability, certainty with respect to its statutes of limitations. I see my time is up, Your Honors.
Thank you.
Thank you.
Just to address that last point, I don't think that is a realistic parade of horribles. Justice Friedman in her benchmark decision where she laid out what taking Nomura and Morgan Stanley and for the trial courts laying out what a failure to notify claim would state, basically said that if there would only be, after the 6-year ACE window, there would only be nominal damages available. So the idea that there are going to be endless failure to notify claims, I think, is not, there's nothing there to be gained by them. Plaintiffs have litigation costs as well. If there's only nominal damages, there's no point in them. Also, we've had years of subsequent activity in there. I don't think there are new failure to notify cases that have been filed in any real sense. So I think that that's not a realistic thing to be focused on.
Why is Barclays on the hook for successor liability if they only bought the shares?
Well, so successor liability, one, they've waived the argument. I think the trial court was correct about that. And so we're permitted to seek discovery on that point. But the answer is that in North Carolina, which is the governing law, successor liability is a matter of equity. And here we have a case where Barclays purchased EquiFirst. They purchased it at and this is all in detail in the complaint, and this goes to our allegations as to alter ego as well. They purchased it with knowledge of EquiFirst potential liabilities. They got a steep discount. They bought it for a song, is what the New York Times said. And they then systematically, first they put it under a Barclays sub, and then they systematically hollowed it out. And our view is that they ended up transferring the assets and liabilities to themselves.
Thank you. Global Merchant v. Tammy Tran. Yes, whenever you're ready.
Thank you, Your Honor. May it please the court, Jonathan Warner for the defendants, Tammy Tran and her law firm. This is not a case, Your Honors, where we are attacking the general rule of agency. Counsel can bind his client both in court and out of court. It's this stipulation, this settlement agreement, that required the signatures of the parties.
Why? Why? The negotiations were going on for well over a year. There was back and forth. Why would the parties why would Global Merchant not believe that the attorney who represented Ms. Tran had the authority to bind?
Well, if we're going to the apparent authority issue, Your Honor, I mean, that's what, if you're asking, why did it require it? Because it said right on it that it had a line for each of the clients. And in fact, before the plaintiff here made its demand on the court, as you can see from the record, the document in front of you has the plaintiff's president's signature. And the entire time of the negotiation, the issue was the parties had to sign. And the reason they had to sign was because of the timing issues.
But your position really is because your client's name was missing on the document. You have 3 signatures, but not Ms. Tran's. Therefore, it's not binding. That's your position.
Well, that is a position, Judge.
Well, I understand, but nowhere in this record did your client disavow any of the terms of the stipulation.
My client couldn't, Judge. That was what happened here. The counsels signed the agreement. Then it was sent off to the clients to sign. The plaintiff's president signed, but my client was in the ICU and couldn't sign, and it was incommunicado. And because the client was in the ICU and we couldn't get her agreement, we couldn't get her signature.
Was there anything stated by counsel for Ms. Tran that, you know what, this is only, it only takes effect if, in fact, Ms. Tran signs it? And I can't get Ms. Tran's signature? He doesn't say that. He says, I've been trying to find her, I can't find her.
Well, no, I
at
couldn't
some point, he
it's not I couldn't-
says that she's in the hospital. But does he at any point say that it has no effect unless she signs it?
Yes, Judge. In the letter to Justice Adams, immediately after, when they tried to get Justice Adams to
No, I'm saying during the negotiations, when the stipulation is entered into, when he's trying to find her and he says he can't, does he say at any point at that time, you know what, this doesn't have any effect until I get her to sign it and I can't find her? Does he at any point state that to the attorneys for Global Merchant?
It's understood at all times, Judge. That's why.
How is it understood at all times?
Why was it understood? Because one, there were provisions in the agreement, no waiver provisions, merger agreement. There's a provision specifically that the clients reviewed and accepted it. This stipulation, this agreement, had contained within it its own provisions that required the client's signature. And that's why the plaintiff immediately goes and gets his client's signature and then sends emails and communications, which are throughout the record, saying, when are you going to get your client's signature? When are you going to get, Your Honor, without those communications and the emails that you see and the messages from plaintiff's counsel, when are you getting your client's signature? Where is your client's signature? There would be no need for that.
So what about CPLR 2104?
I'm sorry,
So we
Judge?
have CPLR 2104. We have a stipulation of settlement, right? And it's signed by the attorneys. It's an agreement between the parties or their attorneys relating to the settlement. Why is that not binding?
Because it wasn't an open court, Judge. This is not, all of the cases that a plaintiff cites are open court, settlement mediations, or in conferences. This case was not an open court stipulation.
And 2104 requires that it be in open court?
Well, that specific provision, Judge, I think relates to the open court, the open court stipulations. A counsel can bind his client, certainly in open court, but this wasn't an open court stipulation. This was an out of the courtroom stipulation that envisioned the client's
Counsel, could you have gotten Ms. Tran's affidavit saying I did not authorize him to do any of this? He had no authority. You could have gotten an affidavit post-ICU during this litigation. You could have done it. You didn't do it. There's nothing on this record that suggests that the terms that were negotiated for over a year before Mr. Warner signed the stipulation on behalf of his client that suggests that there was no meeting of the minds here. I think you're resting on a real technicality.
Well, I am resting on a technicality, Judge, because that's exactly what the problem was. This stipulation had a provision for the client's signature. Now,
But you're attacking the stipulation. As my colleague stated, why is there no affidavit from Ms. Tran stating, I never agreed to that, and I also, Mr. Warner did not have the authority to bind me to this agreement because I never agreed to it.
Because the motion was made, Your Honor, the motion was made to, for breach of this stipulation within 6 weeks. The client was still in the ICU in Texas for 2 months. There was no time to get an affidavit from the client that said, I didn't authorize this. She's in the ICU. That's what they did here. First they had the stipulation signed by their own client. Then when the defendant couldn't sign it herself, they first tried to get the judge to so order it. She wouldn't so order it. And
so
then
they moved in September of 2023.
And was signed August 7th, Judge. It was within approximately a month.
And so you're stating that in no time were you able to request additional time or state to the court, well, my client is in ICU and therefore she can't.
Well, if you look at our opposing papers, Judge, that's exactly one of the things we said, that this stipulation required the client's signatures.
No, but did you state that we can't get her signature because she's still in ICU?
I don't believe, Judge, that was said to the judge in a demand.
Because I didn't see anything. I thought from the record that at some point in time she was out of ICU during the pendency of the motion.
Not prior to the time that the motion went in to be heard, Judge.
I'm sorry?
Not prior to the time that the motion went in to be heard.
But prior to when it was determined, right? When it was decided. I didn't see anything in the record in terms of how long she was in ICU, when she was admitted to ICU, when she
no, there's
left
nothing.
ICU.
There's nothing in the record.
And also, the fact that she's in ICU does not mean there's nothing in the record as to what caused her to be in ICU. That you're in intensive care does not mean that you are not able to sign off on documents, et cetera.
It doesn't necessarily mean it, Your Honor, but
I don't know. My point is,
it's not in the record, so I'm not going to speak outside the record, Judge, as to how ill this woman was. But
right, there's nothing in the record would tell me how ill she actually was, so that she was incapable of either signing the stipulation or signing an affidavit stating that she didn't agree to the terms of the agreement.
No, there's nothing in the record, Your Honor. But what you do have in the record is the conduct of plaintiff's counsel. You have the conduct of plaintiff's counsel. They get an agreement signed by both counsel. They don't mark the case settled. The case is adjourned for numbers of months to allow for the execution of the agreement. They go and they get their client's execution of the agreement. Defendant doesn't execute it.
Yes, thank you.
Pardon?
Thank you.
Thank you, Your Honors.
Last but not least, State of New York versus Popel. Yes, whenever you're ready.
Thank you, Your Honor. May it please the court, Zach Struver, Mental Hygiene Legal Service for Louis M. This case is about the NYPD shackling Louis M. to a psychiatric hospital bed for 26 days, and whether he had recourse to the great writ of habeas corpus to be freed from his restraints. Mr. M. was brought to a locked psychiatric unit at Jacoby for treatment while under arrest.
So you can see that the appeal is moot, right?
Yes, Your Honor, the appeal is moot, but the mootness exception applies here. There's a likelihood of repetition because the NYPD policy is still in place. We also cite cases from the Supreme Court in New York County and in Kings County where courts have dealt with similar situations.
But my understanding is a writ of habeas corpus would require the patient to be immediately released from the person being illegally confined. Here, we're talking about the shackles, but it's still not clear whether at the time Louis M. would have been released from the facility. You agree with that? So you're trying to apply the writ to the shackling component of this situation.
The shackles were the illegal restraints.
That's what I said, the shackling, but not the retention in the facility, of course.
We were not seeking his release from NYPD or hospital custody. We were seeking his release from the restraints.
Why wouldn't an Article 78 proceeding have been the way, and then an application for emergency relief?
An Article 78 proceeding wouldn't have been proper here because there was no final decision made by the agency, the NYPD, and there was no internal procedure for review, so Louis M. wouldn't have been able to exhaust. And, you know, an Article 78 also would not have allowed the court to order the removal of the restraints.
Well, if they denied a request to be released from the restraint, wouldn't that be a determination which could have been challenged in an Article 78?
The issue was that Mr. M. had no clear right to challenge it within the NYPD. There was no procedure. There was no final agency decision maker here. Even Jacoby said, our doctor asked to have the restraints removed. The NYPD declined. Sorry, there's nothing else we can do. So what was Louis M. supposed to do in those circumstances? The writ of habeas corpus is the mechanism for seeking the removal of unlawful restraints in New York. The statute makes clear that somebody being otherwise restrained in their liberty is entitled to seek a writ. And in these circumstances where somebody is shackled in a...
Even if it was granted, he's not going to be released. He's still going to be restrained. You're really challenging the conditions of the confinement.
We're challenging the restraints themselves, which are the confinement. Those are the unlawful confinement. We're not challenging the other conditions of being confined in the hospital. The restraints themselves under the CPLR 7002A are the shackles. So we were seeking the removal of the shackles in this situation. And it's not a conditions of confinement case because this is not about something that's occurring during the confinement, such as in the cases that are cited in...
He's shackled during his confinement.
He's shackled, and the shackling is the unlawful confinement.
Right, but that's a condition of confinement. That's a condition of confinement.
Well, it's an unlawful restraint, which is what CPLR 7002A says.
But you can't, habeas relief is not available when you're talking about conditions of confinement.
Habeas relief is available to seek the removal of an unlawful restraint, which is what these handcuffs and shackles were. In this case, the standard is Youngberg v. Romeo, which is, the Supreme Court said, that in a psychiatric setting, a patient is entitled to be treated as a patient. And they weighed the safety concerns that the NYPD raises against the right of a patient to be treated as a patient. This is not a conditions of confinement case like the ones that are cited in respondent's brief. This is about the confinement itself. Mr. M was illegally restrained in the psychiatric unit. The Supreme Court has said that restraints in psychiatric settings can only be... Yes, sir.
So if the hospital had not taken a position that to remove the restraint, would you have any basis to argue what you're arguing here, putting aside whether the writ is appropriate or not?
Yes, because the NYPD policy inverts what Youngberg says. Youngberg says it needs to be in the professional judgment of a physician, not in the judgment of a police officer. And
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. John Shepwong on behalf of the respondent NYPD. May it please the court. So I think as Your Honors have honed in on, I think it's very important in this case. It is moot because the restraints have long been released, but even on that timing, it's very important to get the procedural framework right in this case.
Well, it's moot, but the problem is this is something that occurs and occurs quite regularly, and unfortunately, by the time that it never becomes ripe because by then the shackles have been removed and we've moved on to the next phase in the prosecution, et cetera.
Well, I think a couple of points on that, Your Honor. I think, the particular circumstances of this case, I don't think that the petitioner would dispute that these were exceptional circumstances. 26 days.
26 days. I do not understand why are you shackled for 26 days and the hospital is stating that there's no medical reason for the shackles to remain.
Well, I think that we need to recall that there is an independent custody here on behalf of the law enforcement. He's in law enforcement custody as well as in the hospital's custody. So it's not just the medical reasons that restraints might need to be imposed. It's also the traditional.
So why would law enforcement need to have the defendant shackled? You have a police officer who is stationed outside of the individual's door. You could certainly handcuff, and I've seen cases where you've handcuffed the defendant to the bed. Why do you need shackles as well?
I think that was essentially what happened here, Your Honor. I think that there were shackles to the bed as well as leg restraints.
But why do you need the leg restraints? Why just not the handcuffs?
Well, I think that the difference here is because of the circumstances of where he is being held at this point. So I think
Does it have to do with the facility you're saying? In other words, if he were in Bellevue where they get patients from Rikers and they have all sorts of protocols for dealing with these kinds of issues, then shackles wouldn't have been necessary, but because it was in Jacoby, it was?
Well, I think that the important thing about Rikers and Bellevue is that at that point, the individual is no longer in NYPD custody. They're in DOC's custody. I think that what's significant here, to Your Honor's point about the facility, though, is that this is not some kind of holding cell where an arrestee would typically be brought. This is not an area where police...
Did they have a police officer stationed outside his door for a month?
There was one police officer, as I understand it, in this stationed here. I don't know whether he was outside the door. I think the allegation was that he was outside.
Well, he would have to be because the defendant was in police custody. He's still in police custody because he has not been arraigned on any charges. Therefore, he's going to be in police custody. Let's get to the habeas issue. So the relief requested in the habeas was that there not be any shackles. Is that correct?
Yes. So it was limited to this conditions of confinement point, I think.
Right. So the point is that if the relief were granted in that the shackles were removed, his body would still be within the custody of NYPD.
That's right, Your Honor. Both in the custody of NYPD, in the custody of the facility, and the custody of the hospital. All of those things would have been true. So I think that when you look at very clear Court of Appeals precedent, in my opinion, in Dawson, I submit that case is on all fours with this one. That talked about challenges to the particular type of confinement and said that was not an appropriate use of the writ of habeas corpus. You can't use the writ to challenge conditions of confinement. So I think that I'd also like to address the point that opposing counsel made with regard to the statute. I think that CPL to Article 70, I think that it's important to remember that Article 70, it doesn't define the contours of the writ, number one. It's a creature of common law, so the courts are ultimately the ones to determine what the writ encompasses. So this point about CPLR 7002, one, it doesn't control the writ, and number two, if you look at the structure of that statute, it talks about detention. Detention is not restraints. It's not handcuffs. It's not shackles. It's detention and release from imprisonment, Your Honor. Unless there are other questions.
Yes. I do have one more question. In terms of, I understand that the doctors here opine that the restraints were not necessary. I'm not sure whether they asked them to be removed, but assuming that the doctors asked for the restraints to be removed, NYPD's failure to remove them, is that in accordance with NYPD protocol?
The refusal was, yes, it was an application of the policy. And I think that brings up another point that opposing counsel made, that this was a final determination. The fact that there was no hearing or grievance procedure available under the policy doesn't mean that it's not a final determination. The difference between whether there's a hearing or not is just the standard of review under Article 78, arbitrary and capricious versus substantial evidence.
How was it a final determination? I'm sorry. How was this a final determination?
So there was the application of the restraints. There was a request to have them removed, and then there was a final determination to say no, that this was agency policy, that we do not remove restraints under
This was all within 26 days?
This was so the point with regard to the petition is that it was brought after 6 days. So what happened after that is not in the record, really. We're relying on
So within the 6
representation.
days, there was an application to remove the shackles, and that was denied?
There was a determination in the record on the petition that it was not clinically indicated, that doctors indicated that it was not clinically indicated, whatever that means. I think that's, I think counsel suggests that was a request to have it removed, but regardless, they didn't think that it was necessary to have the restraints. So that I submit that was the request. That was the and the response to that request from the NYPD was the final determination to say, no, the policy that we've applied applies here. Article 78 is the traditional way to challenge an agency's policy and its application in a particular circumstance, and that's why I submit Dawson is correct in all ways that Article 78 should have been the way this was brought.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court. My name is Gina Bernardi DeFalco. I'm here on behalf of Jacoby. I'm not even going to take my whole 3 minutes. My only point is that Jacoby is not a proper party to this petition, whether the right lies in habeas or not. The only reason to bring Jacoby in is to try to bring this under the rubric of the mental hygiene law, which is not the standard that applies to the police, and what kind of restraints they are using. The kinds of restraints we are using in a clinical setting are different. We weren't using them in a clinical setting. We weren't the ones who placed it. We do not belong here, and the declaration needs to be made that we do not belong here.
And also, this was a habeas, so you did not really have custody of the body.
Well, he was in the custody of the CPEP, the psychiatric emergency room at the hospital, but that application was made to be released. That application was denied. That application is not a subject of this appeal, so it's an implicit concession that the involuntary admission at that time was warranted. And he actually is still at Jacoby now as a voluntary patient. He has not been discharged.
Oh.
Thank you, Your Honors.
Thank you.
Just to respond to the last point, Mr. M is actually now at Bronx Psychiatric Center as a voluntary patient. Mr. M sought the removal of his restraints under the writ of habeas corpus because that was the proper mechanism here. Dawson is not anywhere near being on all fours with this case. That case involved an administrative determination by the prison warden that the prisoner would be placed into solitary, and that was reviewable by Article 78 because it had a final decision. There was procedures for review internally. That's not the case here. This is a case where officers on the ground, who are not executive decision makers, are keeping someone shackled. That is what a writ of habeas corpus is for. It's to seek the unlawful removal of restraints. There's no case law cited by respondents that indicates that removal of restraints is not within the scope of the writ of habeas corpus.
But why is Jacoby here?
Jacoby is here because Mr. M was in their custody. They also were responsible for transporting him to.
But he's being shackled by the NYPD, not by Jacoby.
Correct. He was being shackled by the NYPD, but Jacoby had to. Our view was that Jacoby had to be a part of this case because he was also in their custody, and they needed to be brought before the court as well. The scope of Article 70 might not define the writ, but Article 70 itself says that otherwise being restrained in liberty is within the scope of the writ. The legislature would not have included that language if they didn't think this was part of the common law writ.
So would you, on behalf of your patients in all these facilities, were a facility to impose 4-point restraint, by way of example, seek to release those protocols by way of a writ of habeas corpus?
Well,
based on what you just said here, and I've never heard of this in all the years that I used to do mental hygiene hearings.
4-point restraints.
I just use that as an example.
Right. So the hospital is governed by Mental Hygiene Law 3304, which has several provisions for what the hospital needs to do. It would also be a treatment decision, so we could appeal it internally as a treatment decision and have an administrative proceeding within the hospital to have those restraints removed. That is not the case with the NYPD here.
Thank you.
Thank you, Your Honors.